everyone. Welcome to today's webinar co-hosted by KCAB International and Bird and Bird. Today's webinar will be conducted in English, followed by a brief Q&A session at the end of the webinar. If you have a question, please send it to us by clicking our Q&A button, which can be found at the bottom of your Zoom screen. With that said, let's begin with introductions. My name is Michael Van Molken, visiting attorney here at KCAB International and MC for today's webinar. This is the 15th of the KCAB International and Friends webinar series, and we would like to extend our deepest gratitude to our sponsors, Seoul IDRC, the Korea In-House Councils Association, and the In-House Council Forum for their continued support. Today's friend of KCAB International is the distinguished Singapore-based law firm of Bird and Bird, having extensive experience on today's topic, the rise of IP arbitration. On our panel today is Lijun Chui, a partner at Bird and Bird's Singapore Dispute Resolution Team. Next on our panel is Alban Kang, a partner at Bird and Bird's intellectual property and technology practice in Singapore and lead in the firm's ASEAN and Japan practice. Finally, we have Nick Peacock, partner and head of Bird and Bird's London International Arbitration Team. I will now hand the floor over to Sue Lim, Secretary General of KCAB International.
Thank you, Michael. As just introduced, my name is Hyun Lim, and I'm the Secretary General of KCAB International. It is my great pleasure to provide these welcome remarks to another of our KCAB and Friends webinar series titled The Rise of IP Arbitration. Traditionally, IP disputes have been litigated rather than arbitrated. However, as the title suggests, IP arbitration is on the rise. Considering that IP rights often need to be enforced in multiple jurisdictions at the same time, international arbitration dispenses the need to litigate through several national courts and instead provides a solution through a single neutral proceeding. Furthermore, the end product of arbitration, arbitral awards, facilitates enforcements thanks to the large number of signatory states to the New York Convention. The benefits of resolving IP disputes through arbitration appear endless if one starts to count them. For example, arbitration allows for a higher level of confidentiality and more flexibility, such as limited discovery rights, which is suited for disputes where data can be very sensitive. The ability to nominate arbitrators with relevant expertise, as well as a limited right to appeal, leads to an accurate and quick resolution of disputes. These are also cited as benefits. However, even today, IP dispute remains a relatively untapped area in international arbitration. In 2020, among the newly filed cases at KCAB, 11% related to disputes arising from software development, another 2.5% related to IP disputes in fields other than software. This figure represents only a small portion of the entire caseload. Regardless of the current statistics, the potential is still there, especially when nowadays the importance of intellectual property rights and along with that, the potential for related disputes is steadily increasing. Just by example, among the awards rendered in 2020 under the KCB rules, an online video game developer was awarded damages of US $240 million, the largest sum of award ever to have been awarded in a KCB international matter. The Korean legal regime is also becoming more receptive of arbitrating IP disputes. The Korean arbitration law was revised in 2016 to expand the scope of arbitrability, widening the doors to include IP disputes. While there is no separate IP panel established at the KCAB, based on the 2020 statistics, about 30% of the arbitrators in the KCAB International Arbitrators Panel listed intellectual property as his or her primary or at least secondary field of expertise. Perhaps this high proportion is not so surprising, considering that Korea is an advanced economy and much of its growth is reliant on new technology. Thanks to our colleagues from Bird and Bird, today's webinar will provide us with further insight on recent developments in this area and examine what factors parties need to be aware of when planning to take their IP disputes to arbitration. And with that, thank you, and please enjoy the webinar.
Thank you so much to the KCAB for such kind introductory remarks. So without further ado, we'll try to go into the presentation. Just give me a moment to share the screen for our slide deck. Yeah, I know. Just trying to get to the first. Hang on, need to get this. No, we need to go back to Zoom. Yeah. All right, can I just get an indication perhaps from the KCAB team that our screen is being properly shared? Nicholas, is it all good?
We can see the PowerPoint program, but it's not on slideshow presentation at the moment. You may need to press enable editing to go into it and then hit present.
Okay.
So start the slideshow and then share that screen of the slideshow.
Okay. Are you getting the right visual this time?
Not up yet.
Okay. Are we good? Nick, do we have the right visuals right now?
I think you're sharing your screen rather than the slideshow presentation. So we can see at the moment your screen with the next slide, but not the presentation itself, the slideshow.
Okay. I think without perhaps spending more time on this, let me just spend another 30 seconds to try to work this out.
Let's see if I can do it from here.
Okay. Ah, that looks perfect.
Okay, away you go.
Thanks for helping with the troubleshoot. Well, again, I think we'll just move on to the next slide. I think in the first segment, we're going to discuss why IP arbitration. If we can move to the next slide, please. So IP rights these days, as a reaction to the amount of innovation that's taking place, have become more important than ever. IP rights, so we're talking not just about patents, but also copyrights, trademarks, and trade secrets. And while seeking to protect IP rights or enforce agreements, licensing those rights, right holders have traditionally turned towards litigation, where they must often pursue proceedings in multiple jurisdictions. And due to the potential challenges that might be faced in court litigation, including that of a public forum, unfamiliar laws and procedures, and perhaps judges of varying IP law expertise and experience, there could be considerable difficulties associated with IP litigation at times. I think as a reaction to that, there are several types of disputes or IP disputes that would typically be a little more predisposed to IP arbitrations. And on the first slide here, you can see that there's quite a sampling of the type of disputes that we're talking about. For global licensing agreements in particular, The beauty of arbitration would be that it allows a licensor to avoid the risk of a validity ruling that has effect in relation to third parties, and therefore presents a symmetrical risk for licensors and licensees. Take, for example, in the typical litigation setting, a licensee may attempt to defend itself against a claim for non-payment of royalties by asserting invalidity or enforceability. And if the defense is granted, the patent would then be invalid as to all licensees. In short, by attempting to collect royalties from one licensee, the licensor put its royalties from all licensees at risk and thus faces an asymmetrical risk. In arbitration, an invalidity ruling would only bind the parties who are party to the agreement, and so the licensor's royalties from other licensees are not put at risk. I think with reference to this, it illustrates two major points in relation to IP arbitration. And the first being very much that parties have to agree to arbitrate their disputes because arbitration is ultimately a consensual process. It relies heavily and rests on the parties' agreement. The other point to this is you would notice that the disputes that are listed on this slide deck here are very much contractual based. And that then also has an impact on whether the laws of the relevant jurisdiction permits arbitration of the dispute. In some jurisdictions, IP rights are not arbitrable. So even if parties opt to have their disputes or their IP rights issues ironed out within the arbitration sphere, the legislation within the jurisdiction may not allow them to do so. And I think Alban, my co-speaker, will be talking about this a little more later. Moving on to the next slide, I wanted to discuss a little more some of the advantages of arbitrating IP disputes. So one of the key things that would commonly be raised is the speed and efficiency to it. Based on statistics that are made available by various arbitration institutions around the world, the average arbitration would last between 13 to 16 months. This would be in contrast with IP litigation in various jurisdictions that could take up to years or even decades, depending on where you might be fighting the dispute. The other point about arbitration, which enables speed and efficiency, would be the truncated discovery submissions. So in arbitration, for example, in the common law regime, it's quite common for us to have pleadings separate from document production, separate from evidence by affidavits in chief. But in the arbitration process, it's possible to collapse all of this within a submission that's done in the memorial style. So in other words, truncated submissions that could bring about a shorter process. The third is the limited disclosure phases that might be available in arbitration. Unlike litigation, where there might be procedural evidential rules that dictate the pace and the requirements or perhaps expand the scope of discovery, for arbitration, tribunals are generally not subject to such requirements and therefore are free to frame the discovery process as they would like. Finally, as to the last 2 points, the examination of witnesses may be limited by the tribunal, subject, of course, to the considerations of natural justice and a fair hearing, but it would be up to the tribunal to decide whether or not, for example, certain expert witnesses are necessary. And finally, it's well known that the grounds for appeal in relation to arbitration awards are generally highly limited, especially in pro-arbitration jurisdictions. And this means that it's more finality for the parties and less need for there to be multiple proceedings across the various levels of the court. Moving on to the next slide. Just a few other advantages for arbitrating IP disputes. The first relates to consolidation. So as I mentioned earlier in the session, there might be a potential for multiple proceedings depending on where the IP rights may be used, in which jurisdiction, or where the party may be situated. So if parties agree to try to consolidate the jurisdictional disputes within one forum in arbitration, there's potential for less lawyers and decision makers to be involved. Witnesses, for example, will only need to testify once as opposed to the 2 or 3 times that they might need to do in multi-jurisdictional proceedings. Tribunal being the dictators of the process may be able to dispense with certain evidence on their own volition. And of course, for businesses, very importantly, you do avoid the risk of inconsistent judgments if you're going to have what is essentially a similar dispute being litigated 2 or 3 times in different jurisdictions. The second point here relates to choice of arbitrators. So because arbitration is highly consensus driven, the number of arbitrators in the tribunal is one which the parties can decide and dictate on. The second would be the kind of qualifications and expertise the arbitral tribunal would be required to have before they can decide on a dispute. And later on in the final segment of this session, we will be discussing some of the strategic considerations in choosing your arbitrators for IP disputes. And lastly, on this slide, confidentiality being one of the key advantages to arbitration is extremely well known. In this case, it's important also to bear in mind that most of the time, what's kept confidential is not just the contract itself, but also the very existence of arbitration. And by extension, that also means that the outcome of the arbitration may be kept confidential, with the consequence that perhaps a licensor might not necessarily have a negative decision held against the licensor in relation to multiple licensees. And of course, last of all, you can protect your commercially sensitive information and other business secrets. In my final slide, some other very well-known advantages to arbitrating IP disputes. As was mentioned earlier, there's international enforcement of arbitration awards. So unlike litigation court judgments, where the enforcement in other jurisdictions may be slightly more challenging, for arbitration awards, thanks to the New York Convention, you're looking at enforcement in more than 160 countries. And of course, there's a lot of statistics and reports around how parties to an arbitration would generally be compliant with the arbitration award that was issued in the proceedings. The second point here refers to, it relates really to forum neutrality, which is especially key for businesses and companies going into high-risk jurisdictions where perhaps the confidence in the local courts of the high-risk jurisdictions may not be as high. And to ensure that there's a fair or commercial result, parties would want to shift the center or the forum of the dispute to somewhere which is neutral and where they can be confident that a fair result will be reached. Last of all, while there are usual litigation rules around how costs should be allocated, and it would be the usual principle that costs would follow the event, meaning that the winning party should be able to recover costs. Arbitration enables parties the choice to decide how costs should be allocated in advance, and also depending on the predisposition of the arbitration tribunal, the winning party may be able to recover a higher percentage of the costs than they otherwise would in court litigation. So that concludes my section on the advantages of arbitrating IP disputes. And at this point, I'll hand over to my co-speaker, Alban, to talk through the limitations of arbitration in relation to IP disputes. Alban?
Yeah, thanks, Lijun. Right, the next section deals with what are the limitations of arbitration. Move to the next slide. Actually, it's only one slide because it's quite it's a single issue with a multitude of complexity to the answer. The question really is not, what are the limitations, but really are all IP disputes arbitrable? And that is really the focus of what I'm going to talk about today. Essentially, there are two types of IP disputes that that lead to sort of a need for resolution, and these are what we call the infringement of an IP right or a breach of an IP licensing agreement. Generally, IP rights are territorial in nature since they are usually governed by national statutes, and therefore national courts often assume jurisdiction, or not often, always assume jurisdiction over any IP disputes within the territory. But when it comes to arbitration, which as Lijun has mentioned is something that has to be consensual between the parties, there are essentially two main limitations to IP arbitration. then the first main issue is really the arbitrability of IP disputes. And the second consideration is really the enforcement of the IP arbitration award, assuming finality of the award has been achieved. Arbitration of IP disputes really depends on what are the real issues that are raised in the dispute itself. Issues pertaining to rights and obligations arising from the contract itself, for example, licensing term, for example, whether or not the accounting period or the financial numbers are correct. These are generally regarded as contractual issues and are arbitrable. Issues pertaining to rights evolving from government entities, for example, whether a patent has been issued by a state is valid, may or may not be regarded as arbitrable depending on the jurisdiction in which the rights have been granted. So, as a general rule, there's no general rule, I would put it. It's not a one-size-fits-all. But generally, most national laws tend to allow arbitration for all IP disputes, but the awards that are rendered by the panel may not necessarily be enforceable by the government entity that has granted the IP rights, and is only enforceable between the parties, which is what we say an inter partes judgment. And then there are some countries where the national law prohibits even the arbitration of any IP disputes, such as in South Africa. So one needs to consider in an arbitration whether or not you are just disputing over the contractual terms of the contract, or whether or not there's an issue of infringement, and whether or not the validity of the IP right is being challenged. And most often not, most of these disputes relate to patent disputes, because it is often in patent disputes that the validity of a patent is normally put in issue as a defense to an infringement. Obviously, if you don't have a validity or an invalidity challenge as your defense, then it may not really matter. But in most instances, parties to disputes in patent infringement cases will try to raise the issue of invalidity, because that is one of the ways where you can prove that the patent that was granted was invalid, and therefore you don't have to pay any royalties per se. But arbitrability of IP disputes varies from jurisdiction to jurisdictions. And there's a difference between common law and civil law countries. In terms of the common law countries, the UK, for example, the arbitrability of IP disputes has largely been recognized judicially, and that patentability as well as validity can be arbitrable, except that any award that is made is only binding inter partes, and that it does not bind the patent office or the state entity that issues the patent. Also, under UK law, a party cannot be compelled to arbitrate validity and infringement. In other words, it has to be, coming to arbitration has to be consensual, and you cannot enforce, or you cannot force one party to an arbitration. In the US and Canada, in the US, there is federal statutory law which provides that parties can arbitrate patent disputes through the inclusion of arbitration clauses in contract involving patent or through mutual agreement. But again, any awards that affects the validity of the patent will have no effect on third parties, and therefore the judgment is purely inter partes. In Australia and Canada, there are no express statutes on arbitrability of IP disputes, but generally this has also been accepted, and the position is similar to that of the UK. In Singapore and Hong Kong, for example, there has been specific legislation enacted which allows for arbitrability of IP disputes, In Singapore, for example, the Intellectual Property Dispute Resolution Act of 2019 has made it very clear that IP disputes are arbitrable. Civil law jurisdictions are slightly different because the legal system in some of these countries in relation to challenging patent validity are also different. So for example, in Switzerland, patent disputes are arbitrable, and arbitral awards for patent validity will be recognized by the Swiss Federal Institute of Intellectual Property, or the equivalent of the Patent Office. In Belgium, for example, patent disputes are arbitrable, and if the award involves a decision on the validity of the patent, that award can be registered with the Patent Office. France considers IP disputes non-arbitrable, but there is some legislation that has been discussed, or rather some discussion on implementing legislation to allow arbitrability of patent disputes. Japan and Germany are similar in their approach to arbitration or arbitrability of patent of IP, especially in patent disputes. This is because they have a dual track system. Even in the national courts, if one were to challenge the validity of the patent, one were to sue on infringement of a patent, the challenge to the validity of the patent will not be heard by the court, but rather will be a separate proceedings before the Patent Office. Hence, because of this dual track system, the validity is heard by a different forum from infringement. Generally, arbitrability of patent disputes are not recognized in Germany or Japan. And in China, the law makes it very clear that arbitrations pertaining to patent validity are not valid. So the overriding consideration at the end of the day as to whether or not to go into arbitration involving a patent dispute really depends on whether you're looking for an inter partes judgment, i.e. a judgment that only binds the parties, or whether you're looking for what we call an agronomous judgment, which is a judgment that binds third parties. Now, so long as the patent remains on the register, it is a valid patent and it binds all third parties. So there are situations where competitors may want to remove a invalid patent because patent sitting on the register would block other innovative products from coming into the market, and also perhaps also blocking competitors' own inventions for becoming patented. So even though you may have a dispute privately between the parties, so long as the patent remains on the register, your own other innovative products or inventions will not be granted patent because of this earlier patent that remains in the register. And in such a case, even if you have a inter partes decision which says that patent is invalid, it's not going to help you in your other portfolio of patents or in your innovation and research and development of your products. So in such a situation, it would normally, the preferable route really would be to go through proceedings in the high court, in the court system, in the judicial system, or in the patent office to make sure that, to ensure that the invalid patent is removed if it is found to be invalid. Yeah, so I think that sort of, in a nutshell, highlights some of the issues and limitations to IP arbitration. And I hand over you to Nick, who will talk about remedies.
Thank you, Alban. Hello, everyone from London. Thank you for that those insightful comments from my colleagues, and especially Alban's very helpful tour of various jurisdictions. We did get a question in about IP arbitration in Japan, which Alban has very presciently answered. So thank you for that. I'm an arbitration lawyer based in London. I've been doing arbitration for 20 odd years. And a number of the cases that I've done over that period have indeed been IP related arbitrations, especially around the question of licensing disputes. And as Alban said, you can look at the question of the scope of the license, the term of the license, the status, and importantly, of course, infringement and rights under that license. So what I'm going to talk about now in my short slot is the remedies available in IP arbitration, because of course that is very relevant to you at a contractual stage in deciding whether to choose arbitration as the dispute resolution forum in your contract. And of course, if there is a dispute in due course, and maybe the licensor or licensee offers, rather than going to national courts, to submit to arbitration at KCAB International or another arbitration forum, then you need to ask yourself whether that is the right forum for you and whether you can get the remedies that you seek in that forum. So the first point to make, and it underlines the point that Alban has just made and that Lijun also made, is that arbitration is, of course, a private process. It is born of the contract between the parties, and it is an inter-party dispute resolution process. So, of course, the origin of the rights that are available to you through that process are in the parties' agreement. But bear in mind, it's not just the parties' agreement. The framework for an international arbitration, or indeed a domestic arbitration, is manifold. And so I put on that slide the different elements you'll need to bear in mind. So the rights and reliefs that you can seek in the arbitration might be set out in the arbitration agreement. It might be set out in the arbitration clause that the parties shall not seek, for example, punitive damages. The tribunal is not entitled to award punitive damages. Well, if the parties agree that, then obviously that circumscribes the remedies that can be sought in that arbitration. Look also, of course, to the arbitration rules. Do any institutional rules that you have adopted for the arbitration make any restrictions on the relief that can be ordered by the tribunal? Very often they will be permissive, so they will not set out restrictions in them, but bear in mind and have a look at those rules because they're another part of the matrix that you need to have regard to. Obviously, the governing law of the contract, if you have a contract governed by, for example, English law, then a breach of that contract will give rise to certain rights and reliefs and claims for damages, for example, under English law. So have regard to the law of the contract, and I'll come to that a little bit later. And also have regard to the law of the seat, of course. And as Alban said, certain national laws will cut across what parties can do in international arbitration, whereas other jurisdictions, and again, Alban named many of those, will be quite permissive in allowing the parties to seek relief between themselves through arbitration. So let's look at an example of that and what I mean by that. So this is the English Arbitration Act of 1996. So this is the statutory framework that would govern an arbitration in London. So even if you had a KCAB international arbitration, but the seat was in London, then the English Arbitration Act would of course be the lex arbitrii and would govern those proceedings. So as you see, this act is quite permissive. The parties are free to agree on the powers exercisable by the arbitral tribunal as regards remedies. So again, you can set out those powers in the contract. Should you wish, you can circumscribe those powers in the relief in the contract. Unless otherwise agreed, the tribunal has the following powers. And it's the sort of remedies and relief that you may well seek. The tribunal may make a declaration as to any matter. So, for example, as to the validity of any IP right. The tribunal may order payment of a sum of money, of course, damages or some other kind of payment of sum of money, and I'll come on to that in a moment. The tribunal has the same powers as the court to order a party to do or refrain from doing anything. So that's an injunction, or that's a specific performance. And indeed, the law specifically says to order specific performance of a contract. And the tribunal also has the power to order rectification, setting aside, or cancellation of a deed or other document, such as a contract. So there you have a national law giving a tribunal wide discretion as to the relief it may grant. So what relief, what remedies might you claim in an IP arbitration? Well, certainly, as I mentioned, injunctive relief. You may well be needing to stop a party from using IP rights that are not covered by a grant under a license. Perhaps they're extending beyond what you think you've granted to them and you need an urgent injunction for that. Or conversely, you might need specific performance. You might need the rights that you claim you have under a license agreement, for example, to be continued pending a determination by the tribunal on an interim basis, and I'll come up to that, or indeed permanently. And I've had an example of that in a case to do with brand access in the car sector, where it was very much a question of whether the license continued to require the licensor to support the brand in a certain way. Of course, you can claim damages. The heads and the type of damage that you can claim will, of course, depend on the law of the contract. So it's very important, of course, that you choose a law with which you are familiar and where you know what types of damages you can seek. Likewise, an account of profits might be available under certain national laws in certain circumstances. So if that is a remedy that you want to seek, then check, again, the law governing your contract on whether the tribunal is permitted to grant those rights. Negotiation damages is a very interesting option in IP disputes, and one that I've had several examples of in practice. Negotiation damages are what English lawyers used to call Rotham Park damages, and they are based on the idea in our context that, for example, a licensor exceeds their license and uses IP rights in a way that is not covered by the grant of the contract. One remedy the tribunal could grant, rather than damages, is this thing called negotiation damages, and that is based on a hypothetical. The hypothetical is that if the licensor had entered into an agreement with the licensee to grant the rights that the licensee in breach of the contract is in fact using, what would have been the hypothetical license fee in that negotiation? So that is a measure, a way of awarding relief to a party whose IP rights have been breached by somebody using them without license, and they would not have willingly granted that license. But as part of the remedy, what you do is you say, if I had granted you that license, this is what I would have charged you. And of course, the calculation of that charge can be a complex exercise on which you are likely to seek market expertise and other inputs. And lastly, of course, declaratory relief. A declaration as to the validity of an IP right, as to the ownership of an IP right, as to the scope of any license. But importantly, again, to underline the point that Alban has made, this would be a declaration that applies as between the parties to the arbitration. An arbitration tribunal, which is a creature of the contract, has no power to bind the world as regards the existence or validity of IP rights. And as Lijun pointed out, that may well be a tactical advantage to a party in a particular situation, and it may be a reason why that party would indeed choose to use arbitration. Finally, on the question of relief, I just want to touch on the question of interim relief. So what I've just been talking about are those final reliefs that a tribunal might grant the parties having heard the entire arbitration process. But what about the need for urgent relief? If somebody is currently and very harmfully damaging your IP rights, your brand, or indeed conversely, as I said, if a party who believes they have a valid license is currently being cut off by the licensor and whose ability to use that licensed IPR is being undermined. Where do you go in that situation? And this is just a reminder of the options available to you as a party who has signed an arbitration agreement. What can you do? Well, you might want to go to a national court for an order from that court in support of the arbitration. And that has traditionally been where we have gone in those urgent situations. Go and get an urgent freezing order or an urgent injunction out of a national court while you then constitute your tribunal and start your arbitration. In particular, the reason why you might do this is if you need some kind of order that will bind third parties other than the parties to the arbitration, then obviously the national court will have that jurisdiction, depending on its own jurisdiction and whether the third parties in question are within it. But a national court in principle will have a wider jurisdiction, not just against the parties to the arbitration agreement. So if you need relief that binds third parties, that freezes assets maybe held by third parties, stops their distribution or use, then you might want to go to a national court. However, of course, you can also, in many instances, go to the arbitration institution. Sometimes you can go to an emergency arbitrator. So that is an urgent arbitrator constituted to hear proceedings pending the formation of the full tribunal. Or indeed, you might ask your institution to respond quickly and appoint a tribunal on an expedited basis, so that that tribunal can then very quickly hear the urgent relief application and then go on to hear the full arguments on the merits of the case. And which option you choose is very much a strategic choice based on where the infringement is taking place, the relief you need, where that needs to be effective. So whether or not there is a national court available to you is a strategic question. And do bear in mind that some national courts will issue relief in support of an arbitration that is taking place outside their jurisdiction, but not all do. So if you want to go to a national court, for example, in Vietnam, for relief in Vietnam in support of an arbitration taking place in London, you will need to check whether Vietnam arbitration law and court practice in Vietnam will allow that relief to be granted. And having chosen that example, I don't know the answer. That was what I wanted to say about relief in international arbitration. Now we're going to think about some strategic considerations in international arbitration, and I'll hand the floor back to Lijun to start on that.
Thanks, Nick. So going on to the next slide, we have a couple of points that we wanted to discuss among ourselves in relation to the strategic considerations. The first being the choice of seat or forum for the IP arbitration. Now, Nick, would you be able to comment a little perhaps on how parties would traditionally decide on a seat, whether it be at the contractual stage or otherwise, and sort of what are some of the pros and cons that would be weighed in relation to that particular consideration? Are there some seats that are more popular than others, and why?
Sure, thanks, Lijun. Well, look, this is just to underline the fact that, of course, in the world of international arbitration, it is cross-border, it is international. You have a choice of forums and you have a choice of institutions. So you should think carefully about both, and you should choose a seat in particular that you know supports international arbitration and the arbitration process. Because, of course, what is fatal to arbitration is if you start an arbitration in a seat and then your opposing party rushes off to a national court that then assumes conduct of that same dispute and does not defer to the arbitration process. So you will want a seat like Seoul, like Singapore, like London, where the arbitration process is recognized and supported. And of course, if you're choosing an institution, choose one that you know that's reliable, like KCAB International, like CIAC, like LCIA, like all the other arbitral institutions that you know about. And if you don't know about a particular institution or a seat, and you want to test whether that is a reasonable proposition, then of course you should reach out to international arbitration lawyers like the ones on this call, and we'll be happy to tell you our views on any given option.
Thanks, Nick. So I think a common question that's raised is it possible to choose a governing law for the contract that differs from the seat? So that's something I get very often. Would you share with our participants the thinking around that, the answer?
Sure. Well, look, again, this is one of the joys of international arbitration, is that you can mix and match. And very often when you negotiate a contract, governing law, surprisingly, will be one of the later elements that gets negotiated. And it never ceases to surprise me how my transactional colleagues can sometimes flip the governing law of the contract at the last moment. But in principle, yes, you can readily arbitrate a dispute in Singapore, which is to do with IP rights, where the IPR might be governed by Korean law, for example. So yes, you can certainly mix and match. Again, the important point is to choose a governing law with which you are familiar. And if you are not familiar with it, to get proper advice to understand the contract will work under that governing law.
Yeah, and I think just to add to that, it would be an added plus to be familiar with the nitty-gritties of the governing law in relation to the subject matter of the contract, particularly its treatment of certain intellectual property rights. So I think Alban has mentioned within some jurisdictions, there might be issues with arbitrability of IP rights. Again, if your IP rights are going to be used in that jurisdiction or are going to be registered there, then I think that's pretty much something that we can't do very much about. But perhaps it would be helpful at the initial stages to put these into considerations and then perhaps to structure the contracts such that you can maximize the advantages that might be afforded by various jurisdictions in relation to arbitrability of IP rights, and then try to shift the disputes over to what is a neutral forum. Alban, would you have anything to add on?
Yeah, I think dealing with IP disputes, and again, in particular, when you're looking at patent disputes, there's another dimension that needs to be considered, and that is the law that governs the infringement if there's a claim for infringement. Because as I mentioned, IP rights are territorial. So let's say, for example, you have a licensing agreement that licenses the use of Chinese patents in China and a few other countries, about patents in a few other countries, and it's governed by English law forum in Singapore. And as a result, and the dispute arises from a breach of the licensing term in China, where there is an infringement of a Chinese patent. Then the question comes, how do you determine, under what law do you determine that an infringement has taken place? Obviously, you can't determine it under Singapore law, under UK law, because the patent is granted in China. Then the question becomes, do I then look at infringement under Chinese law? But Chinese law says that IP disputes or patent disputes are not arbitrable. So what's the what law then do I apply? So these are I really don't know the answer. I mean this has always been troubling me. You know, when you look at multi-jurisdiction disputes where one set of rights are governed by one particular set of law. For example, the law that governs the rights of intellectual property rights, and another set of law that governs the relationship between the parties. For example, the contractual relationship between the parties in dispute. So I think that's something that merits consideration at the very onset.
Thanks, Alban. So moving on to the next point, appointments to the tribunal. I think before we get to that, it's quite well known that as far as arbitral tribunal are concerned, parties can stipulate the numbers, the popular choice being 1 and 3 odd numbers. We definitely try to avoid even numbers so that we can have some sort of position or the other by the arbitral tribunal. And I've yet to see an arbitral tribunal that comprises of 5 arbitrators. Now, Nick, would you be able to comment perhaps what usually drives the choice for parties between a 1-man tribunal or a 3-man tribunal?
Sure. Well, I mean, it is often the size of the dispute and the complexity of the dispute. And of course, many arbitral institutions will default to a sole arbitrator, save where they consider that the size or complexity of a dispute requires 3 persons. Parties, of course, often like a 3-person tribunal and take comfort from it because they know that they will, in general, appoint one of those arbitrators. So they have the option to put somebody on that tribunal who will, of course, be independent and impartial, but will recognize their point of view, perhaps come from their legal tradition or from their jurisdiction, and recognize the sort of practice that they want to draw out in deciding that dispute, or indeed might have particular expertise or technical expertise. And I think another short point to make here is to use the flexibility of international arbitration. If you have a 3-person tribunal, do you want to appoint as your appointee not a lawyer, but a technical expert whose expertise will assist you in making your case? And I did have a case a few years ago that was to do with industrial intellectual property and industrial processes. And the claimant put on the tribunal an engineer, not a lawyer, because they thought that that engineer would be well able to recognize when one process was a copy of another process, and therefore to assist the lawyers on the tribunal to recognize that there was, at a technical level, something that looked like a breach of intellectual property.
Thank you. So I think that brings us slightly to the technical sort of expertise that might be required for the tribunal. Alban, in your experience for highly technical patent disputes or other IP disputes, what are the ideal attributes that you think the arbitrators on the tribunal should have?
Obviously, again, in relation to patent disputes, it is always ideal if the arbitrator or even the inferior officer is hearing that the dispute has some technical training, technical expertise in the subject matter. I mean, in the UK, for example, a lot of the judges have some technical experience. They maybe have a basic degree in chemistry or engineering before they become a barrister. But in other jurisdictions like Singapore, for example, where all of us are just purely lawyers without any technical background, and so are our judges, it becomes obviously more critical that whoever's here the dispute should have some knowledge of the technology that's been involved. And in that sense, arbitration of IP disputes has an advantage, because then you're able to appoint the arbitrator or the arbitrators of the tribunal, someone who has the right technical experience and knowledge. I mean, it's a bit like construction arbitration. You would like to get an architect or a structural engineer as a member of the tribunal so that he understands what the measurements mean, what the drawings mean. And I can tell you, I had a case, a patent case before a high court judge who had a lot of trouble understanding line diagrams, engineering diagrams. And so again, this is just from an experience that it's always better to have someone who is familiar with the subject matter hearing the dispute.
Great. So I think some food for thought for all of us in terms of trying to appoint arbitrators to the tribunal. I think the other thing I'll add is, based on my experience, it's not a process to be rushed. You have to look at the candidates very carefully. Very often clients might expect us to come up with candidates within short order, and while we can, it's a process that needs to be carefully thought out, because it's going to be someone who's going to be deciding on your dispute for the next 12, 16, or 18 months. And, it's absolutely important to get the choice right from the start. And as mentioned earlier in the session, I think KCAB on their panel of arbitrators, they do have quite a number of individuals who have IP as either their primary or secondary expertise. So now moving on to the third point, discovery. I think my first question would be to Alban, in your experience, for a number of IP disputes, would there be any particular discovery considerations in ensuring that you get a fair result? Bearing in mind that for arbitration, we can very much build the process, would there be any particular strategic considerations in terms of document disclosure from the other side that one should bear in mind?
Not so much document disclosure, but and the rules of the court do provide, and that is experiments. There are times when, as arising or some of the issues arising from the dispute, you need to conduct experiments, and there has to be very clear guidelines as to how these experiments are to be conducted. You can't have both sides conducting their own experiments, coming up with their own data and presenting it to the tribunal and say, this is how it's done. So normally you would ensure that there are certain procedures of how experiments are to be conducted. It could be conducted by one side, witnessed by the other side. It could be conducted by an independent party. So I think not so much in terms of discovery, but if there are any experiments to be conducted in order to resolve the issue in dispute, then there should be proper procedures set in place. And usually having it by way of an arbitration is easier, because you can then get the tribunal to set down the procedure that will be acceptable to both parties.
So then I think at this point, I'd like to ask Nick to share a little some of the usual arbitration procedures or processes or means for parties to consider the need for such experiments. At what point can a party raise this before a tribunal, and how would it have the overall impact on the presentation of the case at the hearing?
Sure. Well, again, I think The point about presenting your case in international arbitration is to use the flexibility that the process allows. And just to bear in mind that this is not formal court proceedings where there might be detailed rules about how the advocate presents your case and what his or her presentation style should be. So again, examples we have seen in practice include parties really walking tribunals through the technical aspects of the license and the infringement, using presentation materials, slideshows, models, graphics, cartoons, whatever you think will have an impact to try and get across the technical aspects of the case. And again, depending on your tribunal, of course, and your audience, you will want to have regard to their background and the level at which you speak to them. And as Alban said, if you've got somebody with a technical degree in the subject matter of the IP, then obviously that will assist you and will inform how you should address him or her and the sort of presentation that will be effective. But again, the joy of arbitration is its flexibility, and you should try and use that flexibility and discuss how you can make strategic use of your presentation.
Thank you, Nick. So I think in our final couple of minutes, I wanted to stress the point on the potential for parallel proceedings. Again, depending on which party you'll be acting for and what the objectives of the parties might be, parallel proceedings may or may not be something which you would like to happen. And as clearly articulated by Nick and Alban, the orders or results of any arbitration award are only enforceable between the parties themselves, inter partes. So if you're looking for something that's binding on all parties or as against the world, you're going to be looking very much at litigation proceedings. And here I was just thinking, insofar as, for example, someone who's very vigilant about protecting their IP rights might then choose to enforce it on a contractual basis through arbitration. But there might be situations as well where the person might take parallel proceedings in other jurisdictions to ensure that their intellectual property rights in other jurisdictions where, for example, IP rights might not be arbitrable, to then conduct numerous proceedings to ensure that their technology or intellectual property is fully protected. Alban, can you also perhaps share some other instances where a party might actually want to take out other local litigation proceedings, either in parallel or to oppose ongoing arbitration proceedings?
Yeah, I suppose in those jurisdictions where, for example, we have what we call the parallel track system, whereby validity and infringement are decided by two different forums. So you may want to look at the infringement by one forum, and that could be the Arbitration Tribunal. But because validity, has to be determined by the Patent Office, and we want to make sure that validity of the patent is binding on all, we may want to consider commencing parallel proceedings, challenging the validity of the patent in the Patent Office, and then you have flexibility in both timing and procedure to see which one should move ahead first to determine the outcome that the best suits your needs.
Thank you, Alban. So I think we have 1 minute to go before we start the Q&A segment of this session. Nick, is there anything you'd like to add in relation to potential parallel proceedings?
Well, no, I think just to reinforce the point that Alban made early in his presentation, which is that the intersection between the public and the private inter-party nature of an IP right and an IP arbitration is the important strategic consideration as to whether you choose to use arbitration, whether you submit to arbitration in due course. And it's not a straightforward question. So, you need to think long and hard about that. And of course, there will be times when you want deliberately to have a strategy that includes and involves parallel proceedings, and there will be times when you want to try and head that off.
Thank you, Nick. So I think this brings us neatly to about 5 p.m. Korea time. Michael, did we at this point hand it over to you for the Q&A?
That is correct. And we do have a few questions in. The first is, what are some of the unique challenges to IP arbitration compared with other forms of international arbitration?
So
I think I mentioned one is the determining what law governs the infringement itself. If, for example, the governing law of the contract or the lex fora, lex forum is not the same as that of the IP right that's being disputed. So can you, for example, determine infringement under a UK law, infringement of a German patent in Germany under UK law? That would be one of the challenges to IP arbitration, I would say.
Yeah, I think to add to that, in addition, perhaps is the technical aspect of it, where in a sense it's not all that unique because we know that there are other types of arbitration, for example, construction arbitration that can be highly technical. But I think it's still something which is worth bearing in mind in terms of how IP arbitration may potentially be differentiated from your other forms of international arbitration.
And the next question we have is, when the parties have chosen Hong Kong or Singapore as the governing law, how do arbitrators treat the English case law that has not yet been followed in Hong Kong or Singapore? And they give an example, for instance, the case of Starbucks Ltd versus British Sky Broadcasting is a landmark case delivered by the UKSC, but has not been applied in the Hong Kong Singapore courts.
Generally, the IP statutes, at least in Singapore, and I believe for some of the Hong Kong statutes, are very similar or we say in parent material with the UK statutes, and therefore any UK decisions will be of strong persuasive authority in Singapore, and I believe so in Hong Kong. So even though the Singapore, Hong Kong courts may not have followed that landmark decision, it would be highly persuasive, and it would be, I think, the tribunal would have no issue following a UK judgment that has not been followed, that has not been adopted or followed in Singapore, unless, for example, there is a decision, a court decision in Singapore contrary to the UK decision. One example is, I think in the UK, the activist case, the Supreme Court ruled that the test for infringement is moving closer towards the US test for infringement, which is the doctrine of equivalent. The Singapore Court of Appeal has ruled that there is no place for that test under Singapore law. So even though there's a specific Singapore decision that sort of distinguishes and not apply a UK precedent. In such a situation, then obviously if the governing law is Singapore law, we will be bound to follow the Singapore court decision.
Yeah, so I think to add to that, that brings us really to the point that we raised earlier, which is to have a very clear-eyed view on what the potential governing law might have to say on certain issues that are likely to crop up in your contract. So if you want to find a position that's more pro your client or your party, for example, then you try to make sure that the jurisdiction's ruling on that particular issue is helpful. So one example that I can think of is very commonly for IP disputes, breach of confidentiality is a potential cause of action. And in Singapore, there's a presumption of confidentiality once certain requirements are met, whereas I think under English law, the position is slightly different. So depending on whether you are a recipient of the confidential information, you might actually want to be able to take advantage of the judicial approach, which the tribunal is more likely to follow, as it would be binding on them under the governing law. But I think the short answer to the question is that until and unless it's been adopted as good law within the jurisdiction of the governing law, it's going to be at best something that's highly persuasive.
Right, and we have time for one more question. In some jurisdictions, public policy has been used as grounds for refusal of enforcement. Has this been the case for IP arbitration as well?
I've not come across that defense being raised public policy, so I don't think it really But my answer there is I wouldn't know because I'm not come across that situation. I don't know about Lijun.
I think off the top of my head, specifically for IP arbitrations, we're not particularly aware for that being raised as a basis for refusing enforcement. And there are a few reasons for that. First, as mentioned, IP disputes are traditionally litigated. And until recently, for example, in Singapore, where the arbitrability of IPR was made clear, that wasn't, IP arbitration was less common. But that said, the prevailing consideration and concern was always that the arbitrability or enforcement of the award might be impacted on the grounds of public policy, like the question poser has just mentioned, that being an extremely broad ground for most parties to try to resist enforcement of the award. And I think Nick might have a little to say about public policy being almost a catch-all for resisting enforcement.
Yeah, I think that's right. Public policy can be used as a pretty vague ground to resist enforcement. Of course, it's not just in some jurisdictions. New York Convention, Article 5, refers to public policy as being a basis for not enforcing an award. So very often, if a party wishes to object to enforcement in their local jurisdiction, they might run public policy amongst other grounds. And public policy can be wrapped up sometimes in some of the other objections. And so, for example, I could well imagine the sort of situation that Alban has described, where if you had an arbitration determining the validity of IP rights under English law, based on an English law contract, and you took that award into China to try and enforce, one of the grounds for enforcement might be, well, Chinese law does not allow arbitration of IP disputes. And therefore, it would be offensive to Chinese public policy to enforce an arbitration award in China that purported to determine rights under IP grants. So I think it's plausible as a grounds for resistance. Certainly, you might see it alongside other grounds. So I think it's right, and it's part of the consideration about the use of arbitration and the forward view about where you might want to enforce, to think about whether the sort of award you're going to ask the tribunal for will be enforceable in the jurisdictions where it matters.
Right, well, we will have to wrap it up there. This concludes our webinar for today. Our next webinar will take place on July 1st, 2021, titled Update on Recent Construction Law Projects. We hope to see you there. In the meantime, big thank you to our panelists for taking the time to join us today, and thank you all of you as well. Take care.
Thank you very much.
Thank you.